right. Hey, thanks for joining me. This is John Kane. Shawnee Rice will be along here momentarily. And this is Let's Talk. We are in our last show for the fund drive, so I want to give you another taste of Murray Porter CD. It is the premium that we are offering for a donation of $55 or more. You simply need to call the pledge line, which is 516-620-3602. That's the number to call to make a donation of any size, become a WBAI buddy, participate in our More Than Mike's campaign, or if you want to pick up a Murray Porter CD, make a donation of $55 or more, and we'd be happy to send you this brand new release from Murray Porter, and we'll play a couple other tracks before we, as we go through the show. You can also go online. You go to www.give2, that's the number 2, WBAI.org, and you can follow the prompts to do all of those things there as well. Look, we do have a pretty full show today, so I'm going to kind of get into it pretty quickly, but let me remind people that tonight I am screening Wind River, which is a major motion picture that is based on actual, occurrences about the missing and murdered indigenous women. It is like I said, it's a major motion picture. It is, it stars Jeremy Renner and Elizabeth Olsen, of course. We have white heroes that are saving us in this film, but it's still the best we got for this subject. I also gotta put the caveat out there. It's a Weinstein film as well, but it is a good film nonetheless. And we will have a discussion about missing and murdered indigenous women after the screening. You will enjoy the film, even though it's a tough subject. And it deals with tough issues. So come out and join us at the Brooklyn Commons. That's 388 Atlantic Avenue tonight at 7:30. We will start the film on time, and then we'll have a conversation with it about the subject matter afterwards. But look, a lot of stuff going on. The news cycle is filled with Robert Mueller and even court cases, state legislation trying to ban abortion, and we're coming into Pride Week for some of these different cities, and so there's so many things going on. But what gets lost in some of this stuff is, and it's what I come to New York for, is to inform some of the folks on issues that you might have missed in the news cycle. And for all of the talk about Supreme Court and again, whether Roe v. Wade is under attack, or the fact that Trump has had two Supreme Court appointments. There's a couple of cases that most people aren't aware of, and I'm going to talk about a couple of those and talk more generally about the Supreme Court. But I've got a guest to join me because I've got somebody who knows quite a bit about this, and in fact knows one of the cases that we're going to talk about. My good friend Peter DeRico is joining me from Massachusetts. I want to welcome Peter DeRico, a lawyer and retired law professor from UMass at Amherst. Peter, I want to thank you for once again joining me here on the show.
It's a pleasure, John. Always good to talk to you.
Well, I kind of hit you up last minute, and I was so glad to get a response from you. And I'm sure that you, I'm sure the subject matter kind of interests you, because what we have is this kind of a situation that most people just want to go to their polar corners on this thing and say, wait a second, a Trump appointee, Neil Gorsuch, ruled with the liberals on 2 Native cases, and yes, he did. And but with you, I want to talk for one thing. Look, I'm not going to deny that there isn't, a right-left thing that goes on with the Supreme Court. Clearly, it does. If you look at where the votes go, this was a 5-4 decision with only Neil Gorsuch crossing over, as they say. But I want to talk about the cases, and you actually were involved to some extent with one of them. So I want to talk about the cases, then I want to talk about the Supreme Court more generally, but also remind people that from a Native perspective, it almost doesn't matter if it's right or left. We get some pretty bad rulings from liberals, and we can talk about the notorious RBG and her citing the doctrine of discovery and some of that other stuff. But let's first talk about these 2 cases. Give me your overview first off, and I'll join in, I guess.
Okay, sounds good. But thinking about before we get to that, just that overall topic about natives and liberal and conservative, you got to go back to Nixon's time. And of course, Nixon was in his administration that brought Environmental Protection Act, and he tried to do more Medicare and all that. But he also was the one clearly to call a halt to the so-called termination policy, whereby the federal government was specifically aiming to so-called terminate the existence of Native nations, and Nixon was against that. He also was, he agreed with the Taos Pueblo to allow them to have control, although the U.S. still claims ownership, but control of the Blue Lake. So that should confound people who think back to, somebody they think of as a conservative president. They got to recognize that either they got to rethink their whole notion about liberal and conservative, or maybe it's changed so much in the intervening years that who knows what the word means.
Well, and let's not forget, it was Barack Obama who initiated the whole Dakota Access Pipeline. That happened all on his watch. So,
yes,
yeah,
indeed.
And it's real easy for Native people. And look, and there's some strong Native people who are some of those iconic images in Indian country. Suzanne Harjo comes to mind, who are all about, just absolutely, almost unequivocally lining up with Democrats and ignoring the fact that we've had some really bad legislation that came out of Democratic leadership. And again, we've had some real bad rulings come out of those who are regarded as the liberal justices on the Supreme Court. So, yeah, and I think we have to put some of that to rest. But and the fact that Neil Gorsuch ruled in favorably, as far as I'm concerned, on 2 Native cases, it's hard to say. Okay, well, a conservative did that, or a Republican nominee did that. Look, these guys all have their own minds, and you hope that they do. And when we see that happen on occasion, when we see somebody cross over, if you want to call it that, and be the swing vote with people that they don't necessarily, that we don't expect them to be aligned with, that should be the norm. It shouldn't be the exception to the rule.
Yeah, and I think what it does is it should force people that are thinking about Native legal issues to look deeper than the surface, so that I remember when Gorsuch was being considered, I did a little bit of research just to see where he was coming from on, his rulings in Native cases, and they struck me as being, he was very respectful in his writing. It was not like Scalia, who was really obnoxious and used kind of epithets about Native people and things like so-called nations. He did that, referred to the Navajo Nation once. So Gorsuch was thoughtful in his opinions, and what has struck me out of these 2 cases. And Herrera versus Wyoming was the very recent one, and Washington Cougar Den versus Cougar Den was the previous one just a few weeks ago. And in the Herrera case, Sotomayor wrote the opinion, and he just joined. He cast his vote in that direction. But in Washington versus Cougar Den, he wrote one of the 2 opinions. There was not one majority opinion. There were 2 opinions that together they were both in favor of the Cougar Den Trucking Company that was operating under the Yakima Nation. So they were positive for the Native side, but they had different reasons. And one of them was written by Breyer, and it was just filled with typical, stuff that Breyer does. He likes to parade how intellectual he is, and he goes on for pages about analyzing some point, and then he says, well, but that doesn't really matter anyway, because, and then he goes on to something else. It's like, well, why did you waste time doing it if it didn't matter? Gorsuch didn't do any of that shilly-shally, fake display of erudition. He just cut right through to the core of the case, and he wrote this opinion. It's not like he just signed on to somebody else's opinion. And I thought that what emerges from it, I want to say something about the Yakima Nation amicus brief, but out of the opinion itself, he says a couple of things which I think are worth quoting. He referred to this case, he says, it's an old, familiar story. The state is dissatisfied with the consequences of the treaty. But to its credit, the court holds the parties to the terms of their deal. It's the least we can do. And he says the least we can do because he indicates how much the Yakima gave up in exchange for how little they actually got in the treaty. He goes into that. And then he says, not only does he uphold the treaty, but he doesn't give any indication that there's any way that the state or the federal government can get around the treaty. He says if the state and federal governments don't like the result of the treaty, they're free to bargain for more. In other words, he says this is a treaty relationship, and if you're dissatisfied, you've got to go back into the treaty process. You don't get to just declare that you're not going to do it anymore. So I thought that was really important to see the way in which he phrased it. And so the bottom line for me is that just based on these few cases that I know of, that Gorsuch appears to be a serious reader, careful reader of history, and a serious, I guess you might say, a scholar of Native history.
Well,
So
and as you
all
said,
that's
one of the
good.
things I think is important, and you getting back to what you were saying about Breyer's opinion, and I've seen some of his other opinions. If you just put volumes of information out there, it makes it very difficult for you to cite that opinion and to narrow something down and get to the point. And when you do have somebody like Gorsuch, who when he does write, he's going to cut to the chase, then you can clearly cite this legal dicta that are these opinions as something that can transcend that case. And the problem, with some of these opinions, they become so watered down with just volumes of, and most of those volumes end up being citing pieces of other cases that never really get to the real substance of even those cases. Now, the thing I want to do before we go too far, just so people understand, there's two separate cases. One of them, again, is the Washington versus Cougar Den, is about the state of Washington trying to tax a native fuel wholesaler who is delivering automotive fuel to native gas stations. So it's a taxation and a transportation DOT or use of highway and a tax case and that's the Washington case. On the Wyoming case versus Herrera, that is a hunting case, and that is the state of Wyoming trying, which. And in both cases, you still have essentially the states trying to say that once these territories became states, that the treaties somehow no longer existed, and that was the real crux of the argument in the Wyoming and Herrera was Crow. So that's a Crow case versus the Yakima case in Washington. Yeah,
and I think that what's also crucial in these cases, in any of these Native cases, is what are the lawyers arguing about? And in the Yakima case, for the first time, the Western Shoshone did some attacks on Christian doctrine or Christian discovery some years ago, but it didn't go very far into the legal system. The Yakima Nation was not involved in this lawsuit. Cougar Den was a trucking company owned by Yakima people operating within the Yakima Nation, but the nation was not a party. But it filed an amicus brief, and so-called friend of the court. And in that brief, it raised a direct challenge to the doctrine of Christian discovery. And that has, to my knowledge, has never happened before, that the Yakima Nation or that any Native nation would call it out, name it, and say they're rejecting it. And if I could read a couple words out of that brief, you'll see the strength of it.
Sure,
they refer to the doctrine of Christian discovery as religious, racist, genocidal, fabricated doctrine based on a legal fiction. And they call it a doctrine of domination and dehumanization. And they say the doctrine of Christian discovery is not welcome within Yakima territory and should no longer be tolerated in United States law. We call on the court to repudiate the doctrine in this case and all future cases involving our inherent sovereignty and treaty reserved rights. So they posed it. They didn't just put it in a footnote or something. They had the entire first half of the brief was a statement challenging the doctrine of Christian discovery. And in the second part of the brief, they dealt with the treaty itself. And I thought that was very interesting to see. In those two opinions, the one by Breyer and one by Gorsuch, they referred to that brief 3 times, more than they referred to any other pleading. They referred to the Yakima Nation amicus brief 3 times, but they didn't touch the first part, challenging Christian discovery. They focused only on the treaty aspect.
Yeah.
And when you mentioned that I'd had something to do with this, I was involved in the very late stages of editing of the briefs, and Steve Newcomb also, some very, very smart young lawyers that are working for the Yakima Nation also involved, and the chairman, Joe De Gowdy. very important. In fact, the whole Yakima Council was involved in this thing because they knew how big it was. And in the conversations that led to this filing, we discussed I guess you'd think of it as a strategy. It's like if you actually call out the doctrine of Christian discovery for what it is, it becomes almost undiscussable in 21st century America. You cannot admit that the U.S. property law and relation to Native nations is based on Christian religious supremacy. And so by putting that right out there, what it did was, it seemed to me at least, it forced the court, the justices, to say, well, if we're not going to go with the treaty, we're going to have to get into that muck that's the doctrine of Christian discovery, because that's all that the state of Washington and the U.S. have to say for themselves. And by the way, the U.S. was on the state of Washington side in that Cougar Den case. And so it was clear that they had read the brief because they referred to it. But they shied away from Christian discovery. They put all their weight on the treaty, and that's where the decision came out. And then the dissent, Alito, et cetera, they didn't name Christian discovery, but they were forced into using the doctrines that are tied to Christian discovery. So I think that the time has come where the Yakima Nation has shown it's possible to raise this direct challenge. And if I could add one more thing, take a little jump for a second. A few days ago, Maggie Blackhawk, who teaches law at Pennsylvania, had a column in the New York Times, and it circled around the doctrine of plenary power, which is based on Christian discovery. And this is what says that the Congress can do whatever it wants with Native nations. It can terminate them. It can take their land. It can whatever it wants to do.
Has the power to regulate the metes and bounds of tribal sovereignty, as they say, right?
Yes, all of that. So her column ends up, after she goes through all of this and shows how plenary power is actually used in other areas of U.S. law in a very detrimental way, she says that the time has come to challenge this and that the court should overturn the plenary power doctrine. So here you have a law professor that, to my knowledge, is the first time any one of these professors has spoken out clearly, or litigators, as with the Yakima case, has spoken out and said this has to be challenged. And that reminds me of what happened how did the doctrine of separate but equal get overturned? It was because a group of lawyers led by Thurgood Marshall said the time has come to draw a line here. We're not going to put up with this anymore. And it took tremendous work, tactical moves. Strategic goal was get rid of this doctrine. It wasn't let's kind of get along and go along. And so many of the documents that get filed with the court, or not just with the Supreme Court, with any of these courts, so many of the documents that get filed don't make that challenge. So I quickly went through after, when you and I agreed we'd do this show, I read all of the briefs that were filed on behalf of the Crow Native guy who was charged with hunting illegally, and who the Supreme Court vindicated and said Wyoming doesn't have any control over his hunting. Anyway, the long story short, all but one of these briefs directly actually agree with the U.S. has plenary power. This is a sentence out of one of the briefs. This is the brief for the Eastern Shoshone tribe as amicus curiae in support of the petitioner Herrera. This is a quote. Of course, it is axiomatic that Congress, having plenary power over Indian affairs, has the authority to unilaterally abrogate treaty rights. Now, why would you embrace something that's totally antithetical to the position that you want to take?
That's exactly part of the problem. It's almost like there's a certain amount of sucking up or endearing that they do to like I don't know ingratiate themselves to the court to make these kind of statements, and then suggest that because they have this plenary power, they have to do the right thing. But the whole notion of the thing is wrong in the first place. And I want to remind you that if you go back, and this is what's so weird about the whole right-left court thing. I mean, you had Ruth Bader Ginsburg cite the doctrine of discovery in the Oneida case in 2005. That's not that long ago. And so she cites it as footnote number 1, almost as if and she's essentially citing it as if it's a U.S. legal principle. And she doesn't even cite Johnson v. McIntosh. She goes right to this. This is 15th century church dogma that she cites.
Yep.
And yet you have things like the UN Declaration on the Rights of Indigenous People, which is only from 2007. Actually, it's been worked on for years, and of course, it's got some of the same language that UN Declaration on human rights and everything else that condemn. Not just it almost condemns the doctrine of Christian discovery directly, but it certainly calls out any doctrines, policies, and practices that are based on religion, national origin, race, all of that stuff as legally false, social, morally condemnable, scientifically false, immorally condemnable, illegal, all that stuff. And my question is, if a judge can cite 15th century church dogma as a foundation to build a ruling on, then every time I hear somebody say, well, you can't cite matters of UN declarations. Well, why not? If they can cite church dogma, why can't we throw this stuff out there? Not that it's going to swing the court, but it's like you were saying earlier, just the idea of getting it into the court record and throwing it out there. I also have to remember, let's not forget that it was also Clarence Thomas in that U.S. v. Lara case who challenged the whole notion that there was any constitutional support for this doctrine, the plenary powers doctrine. He says, I don't see it in there. It's not. I mean, he flat out says it's just not there. It's almost been made up, and he calls the court schizophrenic in the process.
Yes, and he's correct, and the court has actually admitted it in a couple of cases where they don't find there's no constitutional ground for this so-called plenary power. It's just made up based on the doctrine of Christian discovery. So it all ties back to that. And I think that the thing about Thomas, we've talked about Gorsuch and Ginsburg, the so-called unexpected actions of people that we think we understand, liberal and conservative. Well, Thomas is another one that he pretty clearly is so-called conservative, but he's the only one that acknowledges there's deep contradictions built into this. Now, if Thomas understood deep enough, he would say, oh, I know why it's contradictory. It's because it's based on the doctrine of Christian discovery. But I don't think he's traced it out to its depth. I don't think he's see the contradiction.
I don't think he's necessarily pro-native. I think he wishes that there wasn't a contradiction. I think if Thomas had his way, this stuff would be very cut and dry, and that there would be some either legislation that would withhold, constitutional scrutiny that would solve and create a plenary powers doctrine. But he's saying, as it exists, it isn't there. So I think he's correct, but I'm not sure that his motives are in the place that I want him to be either. I'm not quite sure about Gorsuch. I do understand that he's not a typical East Coast, conservative. So he has a little different view. But one thing I do have to address with you though is one of the things we always have to be careful when we get overly excited about a ruling one way or the other. At some level, even when we win in these courts, there's again, when we have some of our own people making arguments, backing up something like the plenary powers doctrine or whatever else, we end up losing some things, and a lot of times, even in these so-called treaty cases, we hear over and over again that unless we have it explicitly cited in a treaty that a certain right doesn't exist, rather than the converse saying, well, unless you gave something up, then for instance, if the tobacco issue or even the fuel issue, we weren't hauling motor fuel or producing cigarettes in the 1860s and 1870s, and so to suggest that unless we carved out that right specifically in a treaty and were granted that right, then the courts have oftentimes held that unless it's explicit, we don't have that right. Rather than the converse saying, well, unless you gave up that right, you still retain it right. There are court cases that say that. But in general, and this goes with the liberals as well as the conservatives on the court, oftentimes, unless we can explicitly show where we got it, then it doesn't exist. Reggie, can you give Peter just messaged me? We lost him, so get him back on the line here. But yeah, and I think that the whole point with all of this is that these courts still retain a significant bias. And I guess since we lost Peter, let me welcome Shadi to the program. I know you came in as we were already engaged, so. You remember we had Peter on before,
yeah,
and he's quite knowledgeable, and these cases, I think it's so strange to see that nobody's addressed the idea that a Trump appointee has ruled on 2 cases involving Native people, the Crow and the Yakima, and frankly didn't do what we expect a conservative justice to cite things like some, again, whether it's Scalia's antics or even Alito's comments. But this guy did offer in one of these cases. He wrote an opinion, and it was thoughtful, as Peter was saying. But it also shows that he understands. As much as these guys will stay away from the doctrine of Christian discovery part of this argument, they understand that these states who just find these old treaties inconvenient, it's kind of absurd when you think about it. I mean, Peter, the notion that they would try to suggest that these treaties are ancient and yet they'll still rely on something like 15th century church dogma is hypocritical all by itself.
Yeah, exactly. We got cut off there, so you might have said something I didn't get into. But we're basically looking at a very crucial moment, I think, with the position that Gorsuch is taking, and the Yakima Nation having opened the way, and a law professor calling for overturning plenary doctrine, and a conservative member of the court saying that the whole field of so-called federal Indian law is a mess. If this is the time when there should be a group of lawyers and scholars working together, just like Thurgood Marshall did, to say, how do we take advantage of this moment, and which cases do we try to bring, and which jurisdictions do we work in, that kind of thing.
And we've got to stop providing them with their own argument when our own lawyers are going to cite things like plenary powers doctrine, and this is part of the problem, because these aren't necessarily native lawyers that are taking these cases. They're lawyers who are well schooled in what they believe, but they don't. This is the way I see it. It's like any other, legal firm and field of law, is that you get used to the standard approaches. Exactly. And it's just like what happened before Thurgood Marshall's work, before separate but equal was overturned. There was litigation under that doctrine. It's like, okay, that's the rule, separate but equal, and now we're going to argue that, within that framework, the state ought to do X, Y, or Z, until somebody said, why are we working in that framework? And because that framework, by the way, ties back, that whole business of racism against blacks and the history of slavery, that ties back to the same 15th century bulls. Yep. And the same doctrines that were being used, that Christians had a right to go and enslave people because they were infidels and heathens and pagans. So we're talking about a history that has contaminated huge areas of the law, not just in this country, but in other countries. But this country just happens to be the one that we're in, where this is the battle where we have to deal with it. Well, it's interesting, because one of the things you talk about what these lawyers have become comfortable with. I've got a friend who's battling the IRS. He's generated all of his income on Mohawk land. Much of it has been income that is derived from leasing or renting space and that kind of stuff. And his battle in trying to find a lawyer who will even challenge whether the IRS has the right to tax income generated from a native territory. Basically every lawyer who practices tax law says you're going to lose. You can't make an argument that the IRS doesn't have the power to do that, even though when you read all of the language associated with tax policies over 200 years, you can never find any change, or certainly no consent, but you can find no change that occurs where that taxing authority should have been flipped on as it relates to Native people. So, taxation is one of those examples. We have no problem fighting the state oftentimes over things like taxes, but when it comes to the federal government, it's almost like all of these lawyers have treated it as a foregone conclusion that if you make a sovereignty case or a treaty case against taxation, you're going to lose. And so it's like, well, then how do you pay for that lawyer who tells you, yeah, I'll make the argument, but you're going to lose? I mean, it's kind of a defeatist attitude right from the start.
Well, it is, and it's the kind of thing that if you think about how law gets changed, and you imagine that, let's say you're not representing somebody who's challenging, paying income tax, but you're talking about a major global corporation that's challenging that tax. Guess what? You're going to find lawyers that are willing to work for that. There's so much cash involved, and there's a power game being played out that they know that they can push the boundaries of what has been ruled in the past, and they can challenge what has been ruled in the past.
Yeah.
So I think that it's the kind of thing where the energy, that's why I'm saying getting a group of lawyers together, you get the energy together, the clarity together to say, now's the time, and here's how we're going to do it. And you don't just sit back and do what you did yesterday and last year and the year before. But it's I don't know what the chances are. I know that most lawyers, it's just part of the way the profession works, they don't want to make an argument that somebody says it's kooky, and they don't want to make an argument where a judge says, that's frivolous, you can't argue that. But I also know that if there's enough money involved, lawyers will challenge existing law.
Well, and honestly, and you and I have talked about this before, sometimes a terrible ruling or even terrible legal dicta that comes in these opinions, there's a value in knowing that that's there so you can cite that. When Ruth Bader Ginsburg cited the doctrine of Christian discovery in the Oneida case, not only did that seem absurd coming from not just a liberal justice, but a Jewish woman citing, because it's the doctrine of Christian discovery. She didn't call it that, but let's be honest, that's what it is. And the idea that she basically said lands inhabited by Indians became vested in the sovereigns, first the states, and then first the discovering nations of Europe, Christian nations of Europe, then the states, and then the United States. She doesn't say how. She just says it just became that under this doctrine, and she cites that. Right. But that wasn't the only problem. She actually cited another legal principle that that's called the doctrine of impossibility. And this is again another absurd proposition, because what she cited, I think, a Yankton Sioux case where the courts ruled that it's impossible for a native people who have lost their lands to reclaim those lands and assert jurisdiction over those lands once it's been lost, even if it was lost through fraud. And that case involved trying to sue people off of land. And in the Oneida case, the Oneidas didn't do that. The Oneidas bought the land, and the lower court said, well, the doctrine of impossibility doesn't apply. Ruth Bader Ginsburg says, oh, yes, it does apply, because the idea of disrupting governmental services and that kind of stuff becomes still makes it qualify under the doctrine of impossibility. And here's the hook with that one. So she cites this case, which is maybe 100 years old, or 50 years old anyway, out west, when 200 miles down the road, the Senecas had the Salamanca Lease Settlement Act, which was an act of Congress that laid out a streamlined process for the Senecas to reacquire lost lands, and not just take it into trust land status, but to take it as original title. And that's how the Senecas have gaming in the city of Buffalo, or that was land that was in the city of Buffalo, but is now Seneca land, that was in the city of Niagara Falls, that is now Seneca land. They did it through an act of Congress. So the idea that Ruth Bader Ginsburg would cite in 2005 that it's impossible for Native people to reclaim land, when there was an act of Congress that was already 15 years old, only 200 miles down the road, that clearly said that clearly made her ruling wrong. So I think a bad ruling sometimes, although it's bad for the Oneidas because they didn't argue the case very well, we all should cite these things as wrong rulings and use the opportunity, not just say, okay, well, we lost that one, we can't make that argument again.
Yes, and I feel that what you're pointing to when you talk about these bad rulings, this is also relates. There's a worldwide movement now to call on the Vatican to repeal the papal bull that 1493 and the earlier ones that created that doctrine of Christian discovery. But I think it's actually more important to repeal the doctrine in the law.
Absolutely.
That's where it's having its
I don't care. I mean, look, the Catholic Church. I mean, they lost so much credibility over their child abuse scandal. Who cares what they repudiate? As far as I'm concerned, and again, I go back to the language of the UN Declaration on the Rights of Indigenous Peoples, because I think that. I mean, in much the same way as it was the Yakima put it in their brief, when they say affirming that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. That to me is a statement that who could argue against that?
Yeah. Well, and I want to add to that, John, there's actually 2 studies that the UN Permanent Forum on Indigenous Peoples put out directly on the doctrine of Christian discovery. They had a preliminary study that then was approved and said, okay, now we see that there's enough here. We're going to do a full study. They did a full study, and the conclusion of those studies was they directly called for the repeal of the use of the doctrine of Christian discovery. So it's the UN Declaration itself plus those 2 expert studies that were done.
Well, and the problem is, guys like you yourself and others, when you look at the long chain of cases, not just land use cases, but jurisdictional cases that spring from Johnson v. McIntosh and the doctrine of discovery, and not just Johnson v. McIntosh. I mean, there are other cases where when Chief Justice Marshall in the Cherokee case basically say that Native people have become wards of the state, like domestic dependent nations. Then you get Paul Gozer only a few years ago making that same public statement. So it's not just. I think people have to realize, and this is why we talk about it, guys like yourself and Stephen Newcomb, and what I try to do is make people aware that this isn't just 15th century church dogma. This is stuff that we're dealing with every day today.
Yes, exactly, and that's the other piece about when you said these bad decisions, these bad opinions can actually be useful, is because they're evidence. You don't have to talk to somebody and say, oh, well, 200 years ago, the court did such and such, and somebody yawns when you say that. It's like, who cares? What difference does it make? It's not law now. You say, no, here's where it's law now.
Yeah.
And then you cite these recent cases, and there's no argument then. It's not that, oh, yeah, that's 500 years old. We don't have to worry about it anymore, or it's just symbolic. It's not symbolic. And this is where, back to the briefs that were filed, I was talking about in the Herrera case, this is a brief for the National Congress of American Indians. This is the largest, supposedly most powerful organization of Native leaders that lobby the U.S. Congress. This is right out of their brief. They say that Congress can consider what it thinks of as a conflict with treaty rights and choose to resolve that conflict by abrogating the treaty. Now, how does that get to be an argument on the side of the natives? And they cite the cases that tie back to the Lone Wolf decision, which was 1901 or thereabouts, which is where plenary power comes from, which relied on Christian discovery. So they're shooting themselves in the foot when they do that. And what we're saying is that you grab hold of these opportunities to make the challenge rather than just saying, oh, I guess Massa told us we should sit down here and not raise our voices, so we better not raise our voices.
No, and that's exactly right. Part of the problem is the legal arguments that we make. Oftentimes, like I said, in almost like in some effort to ingratiate ourselves to the court, we yield these huge assumptions that come not from any consent, except for from these lawyers, and then we try to make an argument that makes us sound more like we're begging for relief rather than saying no, you're the foundation of this stuff is wrong. I mean, and so when you get into this whole idea, let's face it, even this idea that the United States declared Native people to be U.S. citizens in 1924, that would have been considered a war crime. I mean, that's the definition of denationalization. The idea of stripping somebody's national charter, national character away, and then imposing your own. Yet, I've seen case after case after case where lawyers said, well, in 1924, we became U.S. citizens. Well, No, I don't necessarily embrace that idea. And the language even of that act and that law also says this law shall be provided no property is placed at risk. That nothing should be lost. There's no personal or tribal property should be incurred upon by this law. So, I mean, this is where, again, some very high-priced lawyers making these arguments oftentimes give the store away while they're trying to make a smaller. They're trying to create a window instead that they can slip something through rather than breaking down the house of cards.
Yeah, exactly. It's interesting because you put a window in a wall, but if you take the wall down, you don't need the window.
Exactly.
And Maggie Blackhawk's article that I just mentioned a few days ago, it was in a column in the New York Times. The title that the editors gave it is "The Indian Law That Helps Build Walls." So, your imagery is right on.
Yeah.
I wanted to read you something. In 1986, there was a case, a district court case, federal case, a construction company suing the city of New York, and it involved a housing corruption scandal. And the city had challenged the lawyers that were arguing for the company. They said they were bringing frivolous arguments to the court and wasting the court's time. And so here's what the judge said in his opinion. He says, attorneys are placed in a dilemma because they have the right, in fact, they have an ethical obligation to present to the court all the non-frivolous arguments that they can make, even if only barely non-frivolous. They're forced by their position as advocates in the legal profession to live close to the line. And then he said, sometimes there are reasons to sue even when one cannot win. Bad court decisions must be challenged if they're to be overruled, but the early challenges are certainly hopeless. The first attorney to challenge Plessy v. Ferguson was certainly bringing a frivolous action, but his efforts and the efforts of others eventually led to Brown versus Board of Education. Vital changes, listen to his last sentence, vital changes have been wrought by those members of the bar who have dared to challenge received wisdom. All right? That's very helpful advice to lawyers thinking, well, I don't know, I don't dare do that, and I'm not being paid enough that I'm going to go through that, that difficult little window there.
Well, and I agree that sometimes, you don't. It's easy to fight if you feel like you're going to win. The challenge is fighting some of these things where there's a little bit more of a challenge to it. Peter, I want to thank you so much for joining us.
Great.
It's great to talk to you. We'll definitely have you back. There's some other things coming down the pike here, and I think it's really important that people realize just how contemporary a problem the doctrine of discovery still is. So I want to thank you so much for joining me.
Yeah, and good luck on your fun drive.
All right, thank you. So, what did you think?
Well, I just maybe you touched upon this before I had gotten in here, but what is your opinion on why Gorsuch sided with indigenous people? It can't be because he knows history well or because he's empathetic.
Well, he's from Colorado, so he's not from the East. So he has a little bit more of a closer, if not first-hand knowledge of some of the native issues because of where he lives.
Doesn't stop a lot of people.
Well, it doesn't stop a lot of people, but this just appears to be his disposition. It's just what the point is, and that we were trying to make was that ruling in these cases, there's no guarantee that a liberal is going to rule in our case or a conservative is going to rule against us because it does, and that's what Ruth Bader Ginsburg proved in the Oneida case. Again, even though I cited Clarence Thomas made cited that opinion in U.S. v. Lara, but never acted on it. He still, even though he says I don't see any place where the plenary power doctrine is in the Constitution. He goes, in fact, it's contradictory. But he still has ruled as if plenary power doctrine exists. So it's almost like these judges will cite the problem, but then say, but the court has held this thing, so I'm going to continue to hold this, even though I know it's wrong. I'm going to continue to hold this way. And so I don't know why. I mean, it was a bit of a surprise. Now, having said that, I'm still not prepared to say that that Neil Gorsuch is our new hero, or that Ruth Bader Ginsburg is the enemy. The problem is the system doesn't necessarily work well for us. I mean, when and Peter's right. I mean, in what he was reading in this opinion, that look, we're going to lose in these cases. That doesn't mean we shouldn't make the argument. So
yeah, it's frustrating though that when you're like, Ginsburg on the Supreme Court, where your job is to literally not go with the standard processes or methods or thinking or analysis in the way you approach complex situations, and yet that's what's happening over and over because that's your one job in these areas.
Yeah, I know, I agree. That's why we should stay out of those courts at all costs, but when we're there, we should not make weak arguments, and that's kind of my point. Hey, look, we're pretty much out of time here, so let me first remind people that we're showing Wind River tonight at 7:30 at the Brooklyn Commons. That's downstairs at 388 Atlantic Avenue. It's a film about missing and murdered, a specific dramatization of a missing and murdered Indigenous women case, and it is a film that calls out the subject, and we're going to talk about it. We'll do a little bit of a Q&A afterwards, so look forward to that. I also want to remind people that we are finishing up our fund drive, so I encourage you to go to the pledge line. That's 516-620-3602. Make a donation of any size to WBAI. Mention Let's Talk with John Kane and Shawnee Rice. If you're interested in Murray Porter CD, Stand Up, for a donation of $55 or more, we'd be happy to send you a copy that we have an exclusive right to offer here on WBAI, and we'd be happy to send that to you. You can also participate in the More Than Mike's campaign or become a BAI buddy. Make sure that when you do so, you let them know that you're a buddy supporting this program. Let's Talk with John Kane and Shawnee Rice. Again, hopefully we'll see some of you downstairs at 7:30 tonight. This is John Kane and Shawnee Rice. And hey, I do want to remind people, we've got Lance Gumbs coming in next week. For those of you who are seeing any of the story in the New York Times and other places about this battle over the wealthy elite, liberal wealthy elite of Long Island fighting the Shinnecock over putting up a sign. Yes, I'm going to have Tribal Chairman Lance Gumbs coming in next week, and we're gonna talk about that and talk about some of that absurdity. This is John Kane with Shawnee Rice, and this is Let's Talk. Yahweh.